for those of you who are new to the subject, what is the right of return? What is its legal basis in international law? Is the right held individually or collectively? If it's a collective right, then if it's not a collective right, then what is the PLO doing negotiating it? And who's responsible then for enforcing it?
To begin talking about what is the source of the right of return, why is it a right, where does it come from? And the right of return is a broader right than just the right of return for refugees. So it comes from at least 3 different bodies of law, from international humanitarian law, which is the law that governs rights during conflict. It comes from an even older body of law, the law of state succession and nationality. And then finally, and more recently, it comes from human rights law, within which we find refugee law as a sort of subspecialty of human rights law. So I'll just briefly touch on the core principles in each of those. Humanitarian law being the one of the oldest, going back to the first really codified rules of 1907 Hague Convention and Hague Regulations. And then the more modern version, which all of you are familiar with because we've had a lot of contest over them here in the United States, which is the Geneva Convention, specifically the 4th Geneva Convention. So in each of those we find support for right of return for people who are forced out of areas or their homes during conflict. And specifically, if you look at Article 49 in the 4th Geneva Convention, and there are 3 articles that relate to that, 133, 134, and 132, and they form a cluster of principles that basically say that there's an obligation on either an occupying power or the conflicting powers to, one, not forcibly transfer anyone during conflict, but if people are required to leave, civilians are required to leave because they're in the middle of a conflict area, then the contesting parties are required to repatriate them after the conflict is over. And the related rules are if civilians are interned, then that interning has to end at the end of conflict, and persons have to be repatriated. So in very simple terms, those are the cluster of rules under humanitarian law that govern. So that doesn't necessarily mean refugees. It can mean just displaced persons.
Can I work one question into
Sure.
that? Okay, so because the 1948 conflict predates the Geneva Conventions, is that these principles representative of customary law? Are they accepted as customary law?
Yes, and in fact, Israel is a party to and has incorporated the Hague Regulations into its law and acknowledges that the Hague Regulations govern. And it has also, although it has contested the applicability of the 4th Geneva Convention, Israel has said, and Israel's Supreme Court has said that all of the humanitarian law principles, the customary principles in the 4th Geneva Convention do apply to the conflict. So we do have that in terms of Israel being bound to these rules. So the second area of law is really customary international law, and that's the law of nationality and state succession. And there's some core principles from that body of law as well. The most important being that when there is a change of territory, so if there's a successor state, which is in fact what happened post the mandate period in Palestine, that when there's a successor state, the obligations on the successor state are to grant citizenship or nationality to all of the inhabitants, the prior nationals of that territory. There's a corollary to that rule, which is that a state in determining its new citizenship law must grant citizenship on a non-discriminatory basis, cannot discriminate on the basis of race, national or ethnic origin to some part of that those original inhabitants. And another corollary to that is that a state cannot denationalize a group of people in successor territory on discriminatory basis, again, based on race, religion, color, ethnic, or national origin. So all of those rules applied and apply as a customary matter when Israel became a state. And then the third body of law is human rights law, which is the one which is actually most contested. And that's because the core principles are embodied in treaties that Israel has also accepted and has not applied any reservations to. That is, said that it is not going to recognize these rules. And a couple of those rules come from the Universal Declaration of Human Rights, two provisions, 13 and 15, which basically grant everyone the right to leave and return to their country and prohibit the deprivation of nationality to anyone. And there are reasons for those two rules being such core rules. We see them reappearing in many different treaties. And one of the reasons for that, of course, is that no state has the right to force a population from their territory onto another state. So it's also about the obligations of one state to another. You can't create a group of refugees when that obligation is going to be borne by another state. So that makes sense in terms of the denationality question, the obligation to maintain nationality, and the obligation to allow someone to return. So the core provision, the sort of embodiment of these rules, is in a particular provision in the International Convention on Civil and Political Rights, of which Israel is a party. And that provision incorporates these rules and basically says that everyone has the right to leave and return, and everyone has the right to his nationality. The corollary being no state can deprive that person of their nationality. So there's a lot of contest about what is the meaning of each of those words. As you can imagine, Israel has developed a series of arguments to deny that those principles apply to Palestinians. But there is an authoritative interpretation of that provision in the Civil and Political Rights Convention, which basically says that the phrase own country is broader than the term country of one's nationality. And the reason for that is precisely because of the state succession and nationality principles that we talked about. If a person's citizenship was tied to a particular state configuration, that state configuration is no longer there. They can't be deprived of their right to that territory just because the citizenship rules have changed. So we have this 1999 authoritative interpretation by the Human Rights Committee, the committee that's responsible for monitoring and interpreting that convention, which says that own country means the country of origin of that individual. It doesn't mean country defined or nationality defined by the current citizenship or national laws. And then the final area, the subcategory, and sorry to lay this groundwork, but I think it's important to understand that where the right of return comes from and how broad-based the legal sources are for this right, and that it's not only attached to the status of refugee, it's also attached to the status of a person, depending on which of these circumstances apply to them. So the final area is refugee law. And here we have two conventions, the 1951 convention and its companion 1967 protocol. And this convention and the related UN agency that was set up to monitor this convention, the United Nations High Commissioner for Refugees, we find some core principles. Again, one is that under the UNHCR statute, there is an obligation of that agency to provide international protection and to access and implement something called durable solutions for refugees. And that's the core obligation under this convention and under the statute. And that means that's driven by something called voluntary choice. Every refugee has a voluntary choice among three main forms of durable solutions. The first one is right of return. And the second is integration in a host country. And the third is resettlement in a third country. But of all of those three durable solutions, only the first, return, is both an individual right and an obligation on a state, because no state is required to absorb someone not of their territory. So host country absorption and third country resettlement are totally discretionary in other states, whether they want to accept this individual or not. And even 60 years of implementation of the Refugee Convention has not changed the fact that there's no obligation on a second state to absorb someone who is not a national of that state. So this explains why all over the world we find the main durable solution for refugees is return or repatriation. And I can give you lots of examples of that, but if you look at UNHCR statistics, you will find that approximately 1% of the world's refugees get resettled. The vast majority return home. And the returning home is out of a sense of legal obligation. And you see that in agreements, post-conflict refugee agreements all over the world.
So the last question you asked is who's responsible for enforcing it, and this right of return. And that takes us to the mandate of UNRWA and the mandate of UNHCR and the protection gap. So you've written extensively on the protection gap. Maybe I can speak a bit about UNRWA if need be, but explain the protection gap between UNRWA, UNHCR, UNRWA's mandate and the 51 Convention, the full panoply of rights that HCR is charged with implementing, and the much more limited mandate that UNRWA has, and how that impacts in real terms on the living conditions and the future outcome for Palestine refugees.
Okay, another course. So the protection gap arises out of what drafters of a series of instruments that I'll try to simplify to talk about, a set of provisions that set the Palestinians in a separate category from other refugees. And this came about because first we have to do a little bit of backtracking and do a little history. But because of the passage of the partition resolution, UN General Assembly Resolution 181, which, and we can talk a bit more about what that resolution did and did not do, but in essence, that resolution seemed to give the imprimatur for dividing the territory of Palestine into two states. And I put these in quotes, Arab and a Jewish state. Of course, in the Arab state, the vast majority would be Palestinian. In the Jewish state, the Jews would be a bare majority. But this recommendation for division, of course, precipitated the forced departure or flight of approximately 800,000 Palestinians, over 60% of the territory at the time. So hard on the heels of the departure of these refugees, the UN took a series of actions. And between 1947 and 1950, created 3 agencies and drafted a set of resolutions and companion instruments. I'm going to try to simplify what the UN did. But what it did was out of a sense that it also had responsibility for the creation of this problem. So that's why we see this rather special treatment towards the Palestinian refugees that the UN had never taken towards other refugees in the world. And you can read this debate in the drafting history itself of these instruments. So the first agency that was set up was the United Nations Conciliation Commission on Palestine. How many people in this room have heard of the UNCCP? A few of you who've done this research. It's amazing how often I speak about the Palestinian issue to audiences who know a lot about the conflict and have never heard of probably the most important agency that was ever established for this population. So the UNCCP was established under Resolution 194, the first resolution after the partition resolution, that both set up a mandate for this agency, defined the population of Palestinian refugees, and then set out a formula for what needed to be the durable solution for this particular population. This language that we see in Resolution 194 actually came from the report by the UN mediator, Count Folke Bernadotte. It was his report to the UN. He was assassinated the day after he presented this report to the UN. It was his report that focused on what the obligation of the United Nations and the world community was towards this population that in essence it had created. So we see the language in Resolution 194 extremely carefully crafted in terms of international law, because the provisions in that resolution, particularly the formula for durable solution, which you find in paragraph 11 of that resolution, is firmly built on the international law as it was at the time, 1948. And that formula is return of the refugees, restitution of their properties, and compensation for losses that cannot be returned. That's in essence what the UN agreed was both the law, the obligation on Israel, and the obligation on the UN to implement. A year later, the UN set another agency, UN Relief and Works Agency for Palestine Refugees, UNRWA. And UNRWA had a very different mandate from the UNCCP. Its mandate was, and UNRWA was initially established only for 3 years as a temporary agency, and it was created to take over the refugee relief that had been going on through UNRPR, other ad hoc agencies, and it was set up only to provide material assistance, humanitarian assistance for the refugees. So UNCCP had what we call a protection mandate, the obligation to carry out this formula, implement the return, restitution, and compensation. UNRWA was set up to make sure these 800,000 plus refugees who are now flooding the Arab states were given relief and assistance until such time as the UNCCP could carry out its mandate. So 2 agencies, 2 different mandates. While this is going on, the UN is also drafting the Refugee Convention and another statute for the United Nations High Commissioner for Refugees, which was completed in 1950. And the debates in the Refugee Convention drafting history are incredibly interesting, because here's the UN being confronted with this enormous flood of refugees. And of course, there are refugees going on, refugees being created in other parts of the world at the same time. We had the partition between India and Pakistan. There was the Korean situation. There were other refugees that the UN was concerned about, but the Palestinians consumed a tremendous amount of focus. And the reason was that they recognized this was something that was from the doorstep of the UN itself. And that was not true of these other refugees. There wasn't the same kind of obligation for having created this problem. So in drafting the Refugee Convention, now the Refugee Convention was being debated for a particular purpose. That was to deal with the refugees coming flooding out of Europe post-World War II. And the sense was that there needed to be a shared obligation towards these refugees, and this new convention was supposed to share the obligation and allow refugees to resettle in other places because they couldn't return back, particularly Jewish refugees from Europe. And so the whole thrust of the Refugee Convention was to try to place a greater obligation on other states to take refugees, which they weren't obliged to do, right? The law was not there. So at the same time, the Arab states came to the drafting table and said, we don't want the Palestinians to fall into this regime where the obligation to resettle people when the UN has already crafted what the durable solution is supposed to be for the Palestinians, and that is return and restitution. So they drafted a provision that set the Palestinians out from the rest of the categories of refugees in the 1951 convention. That article is called Article 1D. It's an infamous article for those of us who work in the Palestinian-Israeli conflict, because it has been interpreted as an exclusion clause, meaning that it has been seen as a particular provision that doesn't allow the Palestinian refugees to obtain the protection of the 1951 Refugee Convention in the same way as all other refugees in the world. An exclusion clause. It has two sentences, I'll come back to them in a bit, but while that provision was being drafted, another parallel provision was being drafted in the UNHCR statute, which basically removes a mandate from UNHCR towards Palestinian refugees in the Middle East. It does not allow UNHCR to provide protection or, in fact, assistance to Palestinians. At the same time, a little bit later, another convention was drafted for stateless persons. Of course, Palestinians also became stateless after 1950, and Israel's legislation, 1950 nationality law. And there's a parallel provision in the 1954 Convention on the Status of Stateless Persons that also says, also has language, same as in the UNHCR statute, excluding Palestinians from the coverage of that convention. So, unfortunately, what was set up as there was a sense from the drafters of these instruments that the Palestinians were already fully covered by these two agencies, UNCCP with a fully set out protection mandate, UNRWA with a humanitarian assistance mandate, and that they did not need this other regime that was being set up for refugees for the rest of the world. Within a few years, it was obvious, by about the late 1950s, it was obvious that UNCCP could not carry out its mandate, and the UN, in a series of actions, began defunding the UNCCP. By the late 1950s, UNCCP had a small office in New York and was basically issuing a letter every year saying it could not complete its mandate. And in the interim period was given resources and basically has done nothing more. I shouldn't say nothing more because it's actually significant. Compiling and digitizing the Palestinian refugee property records. But its protection mandate was defanged and it became basically inoperable as far as carrying out any aspect of the durable solutions or other protection that it was mandated to carry out for Palestinians.
Can I add here just one bit of detail, and correct me if I'm wrong? In its short and sad history, UNCCP, as a functional organization, you're right that it's mothballed here in New York. But in its short history, it did elicit at one point a commitment from Israel to allow the return of 100,000 refugees, which was then rescinded officially by Israel, I think the following year, in 1951. And this is at a time when the Palestinian refugee population was 800,000 to 1 million. And now the population is many times that. And in final status negotiations at Camp David and Ottawa in 2000 and 2001, the number floated was 5,000, 10,000. The Palestinians wanted 100,000. With a population now of 6 million. And now in subsequent negotiations, the refugee issue really hasn't been revisited with any seriousness of purpose. Israel now has reduced the number to a symbolic amount, 5,000, with augmented family unification provisions. So that original commitment that UNCCP elicited from Israel in 1949 and 1950 is far more generous on the right of return than present-day negotiating positions. But I want to talk a bit more about the protection gap and the one functioning agency that exists, which is UNRWA. And I want to define what international protection is first. So the UN Interagency Standing Committee definition is protection as all activities aimed at obtaining full respect for the rights of the individual in accordance with the letter and spirit of the relevant bodies of law, which Professor Akram mentioned, human rights law, IHL, and international refugee law. UNRWA uses a slightly different definition that's quite circular, which is all that UNRWA does to secure the rights of Palestinian refugees. And having formerly worked with UNRWA, I will say that within the agency, the pushback you would get on the notion that UNRWA doesn't do protection work is that UNRWA does robust protection of economic and social rights of refugees, that it provides primary education, primary health, relief and social services, camp improvement, infrastructure projects. The works part has been diminished to basically a pittance of a cash for work program. But in terms of protecting a right to adequate housing, protecting a right to education, protecting a right to health, and a decent standard of living, the UNRWA is doing protection work at that level. And that in recent years, UNRWA is doing much more by way of seeking accountability for violations of civil and political rights by host authorities. In fact, a lot of my work at UNRWA was focused in that area. But again, that UNRWA's role in that area is complementary to the principal UN organs that are engaged on the question of Palestine. And that yes, UNRWA's work in terms of durable solutions is limited, but that's only one of arguably three facets of international protection work. Now, how would you respond to that?
So there's several ways to think about protection, because protection is not just one thing. It's perhaps easier conceptually to think of international protection as a spectrum. On the one side of the spectrum is the protection work that relates to humanitarian assistance, education and health, those kinds of services that are essential to survival but also to dignity. On the other side of the protection spectrum is the one we're most concerned about for refugees, which is the access to and implementation of durable solutions. That is the most important aspect for a refugee, to find a safe place where they can obtain status and carry on with their lives. So at that end, to start with the simplest, UNRWA agrees that it does not have a durable solutions mandate, and there's absolutely nothing in any of the UN resolutions that have subsequently been passed concerning UNRWA, which either commend UNRWA for its protection activities, or basically describe certain protection activities. We have a cluster of different resolutions about that. None of them suggests that UNRWA has a mandate to durable solutions. UNRWA says this itself in all of its materials, and we see this in the General Assembly resolutions that talk about the relationship of UNRWA to other agencies. So that's on the one hand. What about the rest of the spectrum? Legal intervention to stop deportations, intervention to prevent Palestinians from being detained in their host states, intervention to obtain identity documents. On all of those legal areas, UNRWA cannot act. It does sometimes try to act, but the problem is there is no legal basis for that kind of activity, and so UNRWA gets pushback from the states where it tries to engage in those interventions. And this is particularly obvious. Every time there's a new Palestinian displacement, we see this again very acutely. In the Syrian crisis, there's a huge difference between the way Syrian nationals are being treated in the host states and the way Palestinians from Syria are being treated in the host states. And that's specifically because the host states have been telling UNRWA, you don't have the legal authority to get documents, to provide certain kinds of services. And so UNRWA has been very creative about trying to get around this. But in essence, the problem is lack of legal authority. And we saw this in several of the intifadas when UNRWA began what it called the protection officers programs. And I remember I was in Palestine during the first Intifada, and they had rolled out this monitoring program, and several UNRWA officers were kicked out because Israel said, you don't have any legal authority to be doing this kind of intervention. So we have a problem with the basic lack of legal authorization. And we know that the intention of the UN was not to make UNRWA a protection agency. UNRWA has no governing body in the same way that UNHCR does. UNRWA's activities are totally dependent on the discretionary donors' generosity. So if UNRWA really had a solid protection mandate, there would be no ability for the UN to say, okay, this year we're going to give you X amount of money, and next year we're not going to give you that amount of money, because they would have to carry out their core activities, right? So UNRWA's been in a perpetual funding crisis, and so when it talks about these additional sort of protection-related actions, it can't deliver on them, both because of the weakness of the mandate, but also because there isn't a concomitant relationship between the recognition that the UN is obliged to fund this kind of work by UNRWA. So,
sure. So let me just give a bit of background on General Assembly resolutions, most notably Resolution 2252 of 1967, where UNRWA was charged with providing, on a temporary emergency basis, assistance to displaced persons from 1967 hostilities. The program you're describing, which is now today called the Operations Support Officers, was created by a request of the Secretariat for UNRWA to provide, quote-unquote, general assistance to Palestinian refugees. After the Oslo process began, for instance, UNRWA was tasked with providing economic and social support in the occupied territory. But its mandate is an amalgam of General Assembly resolutions, and the interpretation of that mandate in the first instance is the function of the Commissioner General, the head of UNRWA, in consultation with the Advisory Commission, which is representatives of the 28 states that principally fund UNRWA, the largest of which being the United States. So again, the Commissioner General, although in the case of Commissioner CHR&GJ, really did push the envelope in terms of what the protection work that UNRWA did, that discretion is hemmed in by the presence of this 28-state advisory commission. And of course, the General Assembly could also say that UNRWA has exceeded the scope of this mandate, although in the past it has not done that. So for instance, in 1967, when the Commissioner General decided, without any input from the General Assembly, to begin providing assistance to displaced persons from the 6/7 war, it was not until a month later that the General Assembly, on July the 4th, a month after the war, commended and ratified the decision by the Commissioner General to provide emergency aid to these refugees. But I would concur in your position that UNRWA's lack of a mandate is in a real sense, a liability.
There was something else I wanted to answer about
Sure.
prior your other question. Sort of there's another piece to the ramifications, but you should go ahead first, and then I'll come back to that.
But what I was going to say is, okay, so we have a clear protection gap on paper, okay? But what if I were to suggest to you that even if UNRWA had a clear protection mandate, or if UNCCP were revitalized and funded and pursued a durable solution to the Palestine refugee issue, that the position of the government of Israel is clear, and that no amount of a functional mandate would change the reality on the ground. That in fact, the gap left by the demise of CCP and the limitations of UNRWA's mandate is more than filled by the various instrumentalities of the UN that are charged with the Palestine issue, the UN Special Coordinator for the Middle East Peace Process, the Human Rights Council and the Special Reporter on Human Rights in Occupied Territory, the Special Committee on Israeli Practices, etc., and so on. There is no shortage of UN organs that are charged with the Palestine question, and they have failed to break the impasse. So what makes you believe that the reality for Palestine refugees would be different if there was a properly deputized, a properly mandated instrumentality of the UN to deal with it?
So there are a couple of responses to that. The first is what I wanted to come back to on your prior question, which is one aspect of this protection gap, is that once the UNCCP was out of the picture, then the question became, how do you interpret Article 1D now in light of the fact that there's no protection agency? So initially, UNHCR took the position that Palestinians outside UNRWA areas, and UNRWA only operates in 5 fields: Jordan, Lebanon, West Bank, Gaza, and what am I forgetting? Jordan, Lebanon, Syria, West Bank, of course. I don't think of Syria these days as a place for Palestinian refugees. So UNRWA has its mandate only in those 5 fields. So what does that mean for the rest of the Palestinians around the world? So UNHCR took the position that 1D allowed it to have a protection role towards Palestinians, but the interpretation of when those Palestinians were entitled to the benefits of the Refugee Convention under the interpretation of 1D has been hotly contested. So we have approximately a dozen different interpretations around the world, which means that Palestinians, we'll talk separately about what is the effect of all of this protection gap within UNRWA's 5 fields. Outside of UNRWA's 5 fields, we have no unified definition of who's a Palestinian refugee. We have at least 3 operating definitions. Who's a Palestinian refugee? Depends on which state is applying it, depends on which of UNRWA's UNHCR's different notes you're going to be looking at. Depends on where the Palestinian has come from, how many displacements the person has suffered, and how the receiving country is interpreting their having resided in 1 or 2 other states. So I, as a practicing refugee lawyer, having handled many Palestinian cases in the United States, this is the way I first fell into this, by the way, because the ordinary rules for determining who is a refugee don't apply to Palestinians. That's one of the major problems with the protection gap. We don't know who is a Palestinian refugee in any uniform sense, in the way that we can apply the main article that determines who is a refugee from anywhere else in the world. And what is the effect of the fact that now we've got 3rd-generation Palestinians? We have Palestinians who I've represented Palestinians who've come through 3 different countries before getting finally to the United States. All of these factors play into whether the person is going to be recognized as a refugee or not. On the individual level, the protection gap has enormous consequences. Every Palestinian faces this who's trying to find a durable solution. There's no agency that has a uniform protection mandate to the entire population of 11.8 million Palestinians in the world. So that's on the level of outside the UNRWA. In the UNRWA areas, all of the Arab states, because of their position towards the right of return, and their having drafted the provisions, the amendments that became Article 1D, have refused to become parties to the Refugee Convention. We have no operating refugee norms other than non-refoulement, which is now customary international law, no operating refugee norms that relate to the international refugee regime in the areas where the vast majority of Palestinians are. What does that mean? Ad hoc policies at the whim of the states, no agency with a clear protection mandate, no intervention for individual durable solutions for Palestinians. Why do Palestinians from Iraq, Palestinians from Syria have no access to status, no access to identity documents, no access to durable solutions except in those few cases when we find collaboration between UNRWA and UNHCR? Hopefully that's going to become permanent. But I resist the argument that there are no consequences to the protection gap. And they become more acute with every new Palestinian displacement.
I just want to say, so people know, the UNRWA operational definition of a Palestinian refugee is a person whose habitual place of residence was Palestine, mandatory Palestine, between June 1946 and May 1948, and who lost both their homes and their means of livelihood as a result of the 1948 hostilities.
And I want to say something about that definition.
Sure.
Because that definition, exactly as Omar said it, is a definition based on need. And registration with UNRWA is voluntary. That's why it's obviously a lot of people, but only 5.8 million people are now registered with UNRWA. That's a subcategory of the entire population of Palestinian refugees in the world. It's the ones who voluntarily register and the ones who are in need. That definition does not relate to the definition that we find in Resolution 194 related to the entire population of Palestinians who lost their homes and are entitled to the durable solution in paragraph 11 of 194.
I do really want to come back to the implementation. You raise a very interesting point, which is the plight of Palestinian refugees, even within UNRWA's field of operation, is based on ad hoc policies. Once upon a time, the League of Arab States, the Arab League, adopted what was called the Casablanca Protocol. I believe it had 5 articles, and it provided for the rights of Palestinians in the Arab host countries to employment opportunities on par with those of citizens, to residence, to entry and exit of the territory.
Identity documents.
Laissez-passer,
Very
identity
important.
documents. Again, five very, very basic rights. This protocol has broken down entirely. It's a dead letter. Short of full implementation of the 1951 Refugee Convention to Palestinian refugees, or again, a properly mandated durable solutions agency, what can the Palestinian national movement do, the PLO do, to try to improve the plight of Palestinian refugees in the Arab host states?
Well, they will never ask me because I've been thrown out of the PLO offices a number of times. But anyway, they don't think law has anything to do with their particular situation. It's a really good question. I don't think that the Casablanca Protocol is a dead letter. The Casablanca Protocol is actually a very remarkable document. In a lot of ways, if you compare the standard of rights under the Casablanca Protocol to the standard of rights accorded refugees under the 1951 Convention, the Casablanca Protocol is actually more progressive. The reason that I don't think it's a dead letter is that no state has actually abrogated the Casablanca Protocol. And it's simply a question of their, because again of political whims, they're not implementing the provisions of Casablanca. But Casablanca is an agreement. It's therefore a binding contract among the states parties to it. And the Casablanca Protocol was the reason that during the 60s and early 70s, Palestinians were able to travel within the Arab states and go to the Gulf and have lives, get identity documents, reunite with their families. They built the Gulf states, frankly, and had a form of freedom that since we have not seen since that time. And really the first Gulf War was the period when that all stopped. My response would be the Arab states are not going to agree to become parties to the Refugee Convention as long as the Palestinian refugee situation is not resolved. They're not going to. They're persistent objectors to that regime, and there's a reason for that. And it's affecting every single other refugee population that's flooding into the Middle East today. The fact that there is no refugee treaty that governs their status and rights. So the Palestinian refugee problem has huge consequences beyond that population and it has a lot to say about what's going on with the refugees coming from Syria as well. My answer would be, if I were in the PLO, I would be lobbying every single day for the effectiveness and implementation of the Casablanca Protocol. And one of the interesting things is in the last few years, in Lebanon in particular, there have been refugee advocacy organizations that have been using the Casablanca Protocol as a way to advance demands on behalf of Palestinians, Palestinian refugees, for rights to work and other kinds of rights that they have been denied. So a number of years ago, Palestinians were not allowed to practice in about 60 different professions. Now it's about 20 different professions in Lebanon. And that work, I know that sounds dismal, but actually that's amazing. That work was done by refugee organizations using Casablanca as their mobilizing tool because it's an agreement. So I would say for now, that's the most important instrument that exists in the Arab state until the Arab Charter and the new Arab group of experts begins operating, and I don't know when that's going to happen. But Casablanca Protocol was tried and true, has been tried, and was not seen as the problem for the Arab states vis-a-vis their interaction with Palestinian refugees in their territories. So to get basic things like identity documents, now, I'll give you just a quick example. Syrians and Palestinians from Syria in Lebanon and Jordan are having children. The Palestinians can't get documents for their children. So we have another generation of stateless Palestinians being born as we speak.
You mentioned Lebanon, and at the Feta Center at American University Beirut, the director is the former director of Al-Haq in Palestine, Fatah Azam, and he wrote an article very recently published on Shabaka, which called upon the new putative state of Palestine to confer citizenship on its stateless refugees, and thereafter enter into bilateral agreements with other states regarding the status of Palestinian refugees in their midst. His proposal was panned by all of the other commentators on the grounds that Palestinian citizenship would be meaningless in terms of international protection, that the PLO should represent refugees in exile regardless, even without such a move, that they should take advantage that Israel would take advantage of the initiative to push for UNRWA's termination, and that Jordan would take advantage of this kind of proposal to further policies it's already implementing, stripping persons of Palestinian origin of their Jordanian citizenship. In other words, it would open up a Pandora's box of terribles with very little upside. Now, I would say personally, given the very sad state of the Palestinian national movement, that some of these risks may be risks worth taking. However, I do find one counter-argument to this compelling, and that's by a Palestinian scholar in Lebanon, Jabir Suleiman, who has warned that the collective acquisition of Palestinian citizenship would be interpreted by the international community as a solution to the Palestinian refugee question and the fulfillment of the right of return in its collective sense, in its collective dimension, the dimension linked to self-determination. So what are your thoughts on Fatah Azam's proposal and the responses that I briefly mentioned?
So Palestinians have a nationality. Their nationality goes back to 1924, when they were recognized as nationals of the territory of Palestine in the Treaty of Lausanne. And that international status was perfected a year later in 1925 through the British citizenship orders that were passed, and under which that domestic legislation authorized thousands of Palestinians to have passports. And Palestinian citizenship/nationality was recognized the world over during the mandate period and upheld in a series of court decisions in British courts and other courts, and even in Israel as late as 1950. Then in 1952, Israel passed its citizenship/nationality legislation, depending on how you translate the Hebrew, which specifically denationalized Palestinians and created, now there are about 100 different nationalities recognized under Israeli law, but they're tied to, it's only Jewish nationality that has the preference to automatic citizenship. By virtue of the factors that were built into the new citizenship law in 1952, the vast majority of Palestinians could not become citizens. So all of those 800,000 plus refugees were, by the stroke of a pen, de facto stateless.
And I should add there the requirement that denaturalized or denationalized Palestinian refugees was the requirement of continuous presence in the territory of the new state of Israel from its creation until the enactment of the citizen law roughly 4 years later.
So there are a couple of arguments about what is the status of Palestinians now based on that international recognition of Palestinian nationality. That relates directly to Resolution 194's reference about who is a Palestinian refugee and who is a Palestinian. 194 referred to, and we know the debates around this because there's a series of authoritative papers that were issued by the UN Secretariat and the legal advisor at the time. And basically, 194 referred to the entire population of Palestinians who were habitual residents at the time of the conflict and who fled, and everyone who relates their nationality to that 1924 nationality rule. So every subsequent generation is covered. Palestinians as an entire group or category were entitled to the durable solution formula of paragraph 11, and they were all recognized as those nationals, the habitual residents of that territory, under the law that I mentioned, law of nationality, state succession, entitled to return to that, not the territory, to their homes is the language of Resolution 194. So, having said all that, what does that have to do with today advocating for Palestinian citizenship legislation? It has everything to do with it. Because right now, the PLO and Palestinian representatives, and we see this through all of the treaty negotiations, are being asked to make a compromise. The compromise that's been on the table is the so-called Land for Peace compromise out of the Security Council resolutions that completely ignores Resolution 194. It completely ignores the individual rights of the refugees, and basically what it sets up is for some form of resolution of the refugee question, maybe 1,000 people being allowed to return under family reunification, or some kind of compensation to be paid by, and we can talk about the variations that have come out of the different negotiating positions, to be paid by the international community. In return for that, Palestine would be granted some form of a truncated state in the West Bank and Gaza. And how does citizenship play in this? If the PLO drafts citizenship legislation that covers all of the Palestinians who were to be covered under 194, they would be forced to only be entitled to return to resettle in the West Bank and Gaza, whether or not that's where they came from. That's not right of return, and that's the historic settlement that Israel and the international community is trying to force on the Palestinian people. I would say this is not the time for Palestine to be drafting citizenship legislation, and in my own research, it seems to me the optimal solution is what we call a very well-recognized norm under refugee law called temporary protection, which is basically what Casablanca Protocol provides. The Palestinians should have a recognized status, a renewable temporary status tied to the ultimate durable solution to which they are entitled, and they should have that status that grants them all of the rights to work, to identity documents, to travel, to return, that they have under Casablanca and actually that they're entitled to under temporary protection as a norm globally. So that would be my response.
And within that framework, would it be possible for the PLO to exercise diplomatic protection or desirable?
Sure, absolutely, absolutely. It's not inconsistent with having an inchoate Palestine nationality. It's not at all inconsistent.
Okay. I should add that, and we'll wrap it up, but in the days following the November 2012 General Assembly vote to recognize Palestine as a non-member state, the Palestinian president issued a decree instructing the relevant line ministries to prepare to issue identity documents to Palestinians around the world, the diaspora, the refugees, documents to be issued without prejudice to their status in their current host countries. To the best of my knowledge, nothing then happened after that decree was issued.
And I'd like to know how many countries recognize Palestinian passports.
The Palestinian passport disclaims the fact that it's a passport. It said it's a laissez-passer issued pursuant to the Oslo self-governing arrangements. So. Okay, so I think we have a lot more that we could cover. I'll just put it out there for questions. We could discuss implementation, which we haven't gotten to at all. I'd also urge people to read, if they're interested in how this plays in the American system. Professor Akram has drafted, and I think issued a revised version of an amicus brief that's been submitted in Bureau of Immigration Appeals proceedings.
And actually, for understanding Article 1D, probably the best source is the handbook that we've prepared based on the jurisprudence of 23 countries. It's available on the website of Badil, www.badil.org. It's called Handbook on Palestinian Refugee Cases under Article 1D, under the Refugee Convention, second edition. And you can find all of the interpretations, understand, sort of what are the implications of this for Palestinians all over the world.